So it's interesting that I'm following the paper on par because my paper is going to be about the law and the futures of law. I want to begin by narrating a poem by W.H. Auden where he talks about law like love. And he says, "Yet law-abiding scholars write, laws neither wrong nor right. Laws only crimes, punished by places and by times. Laws clothes men wear, anytime, anywhere. Laws good morning and good night. Others say laws are fate. Others say laws are state. Others say laws no more. Law has gone away." So I feel like this particular poem kind of sets the stage in the way I'm looking at the law. And as a young lawyer, one often struggles with trying to reconcile the power of the law with its limitations. So the way I'm articulating, I want to begin by sort of talking about how should we look at law when I'm trying to envision a particular future. I'm trying to basically speak about law as a site of struggle. I'm not looking at law in its sort of procedural form or it's in legislative form, but looking at law as a space where resistance, discipline, protest can all be relatively expressed and negotiated. And I think following the sort of discussion on power, what's intrinsic in the sort of exercise and sort of drama of practicing the law is that power gets negotiated and gets re-articulated in different forms. But a lot of scholars from the critical legal studies tradition constantly try to undermine the power of the law. But having used the law, one thing you start to realize is its potential to correct and its potential to really reimagine new power structures and realize them. But it depends on who is expressing that law and who's articulating that law and whose law is it really. So in my vision, what I've essentially tried to do is look at two essential aspects of the law. One is the question of access to justice and the relationship between law and justice. And the second is sort of the dynamic relationship between law and society. And I think in India, to an extent, we have a healthy sort of two-way street in terms of legal articulation of certain social movements, be it the Forest Rights Act, or if you look at the Nirbhaya protest, which resulted in amendments to the Criminal Procedure Code. At the same time, the law becomes what John Austin said, the command of the state, or the command of the sovereign, which is the law gets used as a trope in different ways to restrict the expression of resistance. So in the two sort of aspects of access to justice and trying to kind of create a more democratic way for the negotiation to take place within the sort of realm of law, I kind of looked at the prospect of opening up the judiciary and the legislative. And when I say opening up, it can be assumed as a form of decentralization, but the way I would rather express it is as a process of gaining agency within the legal structure. So if you look at the structure-agency dynamic. And so with the judiciary, what essentially happens is it's an adversarial system. And the procedural law that gets you to the court finally is such a tedious process that in that entire battle, the question of justice and truth and access to the righting of the wrongs is quite a slow process. It's inefficient, it's cost intensive. And so one of the suggestions that I am making in the paper is to look at mediation as a way of addressing questions of injustice. And by mediation, I don't mean just the Gram Nyayalayas, which have been set up, but rather looking at mediation in the way a lot of legal theorists have articulated it, which is that parties to a dispute get agency to decide what the resolution of that dispute means. But of course, this might sound too idealistic given that each of the parties are situated within a particular power structure and what that negotiation process looks like. So the suggestion I'm making is not to eliminate the adversarial system, but to sort of look at pluralistic forms of dispute resolution. And I think mediation centers act as a really effective way of doing that. The second aspect that I address is the sort of opening up of the legislative, and this is drawing from the example of South Africa, where any law is being negotiated within the parliament. Civil society organizations and impacted communities can represent their interests. Whether they're considered or not is a different aspect altogether. But what I'm suggesting is that we have a three-tier system to the process of legislative, for the process of lawmaking itself, which is, we already have the panchayat system. Why not instill a legislative authority at that level? And the power to veto a particular law, or the power to to kind of tailor-make it to the context. Because I think the interaction between law and society can only be improved if the process of lawmaking is more inclusive. And so that is the sort of second suggestion I'm making. But in conclusion, I think in some of the pathways that I discuss in the paper, what you look at is also an element of this need for innovation in justice delivery. And I think this is some part of it where the sort of examples that I talk about is, which I can go into in the discussion, is the sort of framing of a larger anti-discrimination legal framework through a very bottom-up process, whereas through consultation that the entire legislative process is being triggered. But this is again run by a group of civil society organizations. The second example that I also give is for the sort of social realization of rights. There's an essential link between sort of kind of creating a social memory around it. And an important link for doing that, I feel like, is to be able to go into schools and talk about human rights and talk about aspects of the law. The law is seen as this sort of different language, and there's a gatekeeper approach to the law, which needs to be broken away. And so there's an interesting initiative that I talk about in the paper called Schools of Equality, where legal education is taking place at the school level, and where students have been asked to draft their own constitutions. What would that mean? So trying to not dilute the sort of, diluting the fear of the law in terms of as this abstract body of knowledge that only lawyers tend to be able to understand, to something that's more democratized. And the third initiative that I talk about is where you use more visual methods of communicating the law. But I think the sort of, I would say the crux of what I'm essentially trying to suggest for the legal futures of India is not to look at law in isolation of social struggle and isolation of the existing power structures, but to democratize the legal space is a way that people who are most impacted by injustices have a stake in it and have enough agency to be able to make a difference within that space. Whether that vision will be achieved is yet to be seen.
I just was a bit intrigued by your comment towards the end about lawmaking in a more inclusive way and bottoms up and so on. And the problem, of course, is that all our experience shows that law matters very little how the law is framed, because the process of law, and once it goes into actual practice within the formal structure of law, is very different. One very clear, quick example could be the way after the December 16 case, Justice Verma committee and the whole lot of recommendations which came in, what that committee produced on the basis of which the law was to be made, and what the law eventually turned out to be, and the ways in which now at the third level, the ways in which that law is actually being put into practice, it loses practically all its positive dimensions. I mean, in fact, at some levels could have become even more draconian, far more draconian than the feminists involved in it ever imagined it. So, but there are one could give many other examples, and I don't see how framing the law in a more participatory way actually would lead to more democratic functioning.
Do you think law finally creates the ambit within interventions can be made on social norms? And do you think that you can project that into the future, that in India currently the difficulty of laws to be able to intervene in social norms would probably change, and what could be the reason if it could change, and what would be the impediments?
Don't you think that the established law is law of established society, which is its power structure, and the lawmakers, including Constituent Assembly, it was there, and today's Parliament and assemblies. These are the representatives elected by people who are in continuous struggle with each other, and exploited sections are fighting with exploiters, and dominating people are being fought with by dominated people. So in this, both are together in represented in one representative. So contradictions are represented. So in that sense, what happens to the natural justice? So this law itself becomes the law of the dominating people and exploiting people.
Two separate points. One is when we are talking about law and the implementation of law, there's always this issue of jurisdiction, and everything is based on the law of evidence. And here, if we are talking about an alternate vision of law, we also need to talk about the legal procedure and the mechanisms for this, because very often, because of the law of evidence, a lot of legal justice doesn't come. Ultimately, there's a human being who is sitting in judgment, and that person is bound by evidence. So we need to think of that. The second is, of course, it's interesting, and one does talk about the grassroots upwards legislative mechanism. But when we work at the grassroots, we also know that the power of customary law operates in a very big way. And here, when we are talking about grassroots upwards, who is going to represent the entire legislative process? Is it going to also, further marginalize those who do not have the power to speak up? It's very often, particularly when we work with rural women, we found this, that they're ready to agitate against the government. But if it comes to the local power structure, then it becomes bhauki and all these other issues. So we need to also, in our vision, talk about this.
This last point is very important. I didn't have a chance to read the paper. How even the professionals and the intellectual class regards law as something not handleable intellectually. So how to undertake the exercise of decolonization and a indigenously rooted jurisprudence? Have you dealt with that issue? One. And that's unless that is on the agenda, these distortions, which are very, very criminal, the kind of money an advocate can make, and the judge, corporation, and the advocate nexus is known, obvious, but I have not seen anybody talking about it except one honorable person, Prashant Bhushan, who says next line of chief justices are this, and they will be corrupt and they will not be corrupt. Nobody has the guts to persecute him for defamation or whatever. So this is the level. There is black and white the degree of criminalization which has already happened in the highest echelons of judiciary. Prashant Bhushan has documented that, and we cannot even speak about it. It does not become a political issue. So that's a second.
We often face this dilemma that when something is going, what we think is going wrong in society, we say, okay, let's create a new law, or let's amend an existing law. Whereas in a lot of cases, we see that people are able to deal with conflicts in non-legal ways, okay, customary ways or other ways. I'm not saying necessarily that's good. I mean, sometimes customary ways are also extremely exploitative and repressive. But this move to actually formalize all of our relationships of tension and dispute and so on through law, is it necessarily good? Or can we, and maybe this also deals with a little bit with what Vijayji is saying, that are there indigenous forms of dealing with conflicts, for instance, or tensions, which are outside of the legal, outside of the formal legal structures. For instance, with indigenous knowledge, now every time we talk about how indigenous or local knowledge is being stolen by piracy taking place, we say, okay, let's make a law that will protect indigenous knowledge.
Let's take out a patent on the indigenous.
Or that's even not that much further. But one can say, okay, maybe that there are arguments against that. But still to say, okay, let's have a law which, which then actually takes the agency of actually protecting local knowledge away from the communities themselves and into the hands of, let's say, lawyers or somebody else. So those dilemmas, which I don't know if there's an easy answer.
I just have just two simple, very brief. The thing is that I think when we talk about the future scenario for law or the whole visioning, I think probably it may be good to pitch at two levels. One is that existing society with all its contradictions and inequities and exploitations, I think it has one way of looking at legal systems and laws and decisions are made and everything. And I think some of the things you said does democratize that process. But I think probably we also need to visualize maybe a different set of society in which much more self-regulated or other type of, so you expand the horizons or frontiers where formal legal system probably may have a lesser role to play. I think can't we move to, at least as a visioning exercise, to think, otherwise every of our actions are determined by today or the other. And also in the West there are certain efforts, if you talk about the first set of things in the existing thing, where a little bit of participatory, where different stakeholders or different interests are brought together, because they also carry a particular knowledge system from the location they come from. And that is also being integrated into, for example, these whole questions of dam removals in the US, for example. It's not a decision which is imposed to some extent, where the people whose stakes are involved in that decision is also participates in that type of thing. So there are different things which you can bring in. But I think probably you could push your thing a little more if you look at a little more, much more self-regulated type of systems or societies.
I think, I feel, this experience I used to think, when this all law, everything, when the community, the society is self-reliant and the whole law things is not at all necessary. Example, and you say Raleigh city, just go there, right? There may be other things, for researchers you may be finding a lot of things, but go there and 20 years, 30 years you see what is the relevance of law for me as a villager, it doesn't find any relevance. If at all something, law tried to intrude there, sometimes disturbance happen, one. The second is, even massive way, the whole state failed before the fishermen community in tsunami. All laws failed, all laws. It may be a prime minister, chief minister, everybody failed before them. In tsunami, rehabilitation, everything, the whole law was amended or even practiced in such a way according to their community, according to their own wish and everything. Small intrusion only happened. So what I feel, more and more self-sufficient, self-reliance is built with the community, and the relevance of law will slowly even coming down. That's what I feel.
Conformity to some norms is the foundation of a Sabhya Samaj, civil society. Right? And that's what we distinguish our animal state in our evolutionary history. And this is very far back. It's much older than settled agriculture. We think that the departure point is where we became more than the rest of our animal cousins. Because at one point we were all similar. So maybe I'm talking 50,000 years ago. What is the residue of that today? Because I find that it's a primitivist kind of manifestation when there is on certain issues, there's a public demand that as though in this case the law should not apply. Let's just go get this person. Somehow this is so heinous, it is so unbearable to, either it is an actual violent crime, as in the case of Nirbhaya, or it is now this current emotion that has been whipped up on nationalism. But the idea that our passion for justice is greater than the procedures we have agreed on. Is it that people don't feel we have agreed on them, that they are alien to us? It's not.
No, I think all the points are well taken, and I think just to begin with Arpitha's comment about how does the framing of law really empower or even act as a way for, and there is dilution after that process as well. How would it really make a difference? I think for me, the way I look at the role of law is whether you want to use the law or you don't has to be a choice, firstly, whether you want to call upon the law or not. And that's an ideal situation. But when you do call upon the law, it should be in a form that it really applies to a contextual reality. And that's the main objective when I look at this kind of participatory legislative making process. Because the distance between the law, the context, and the legal issue is so divorced from each other that sometimes what essentially is a legal problem gets translated into a whole other set of issues and gets framed in a very different form. Just to give an example would be an interesting case that came out. I think this was in one of the issues that we were working on in Orissa. What was essentially seen as, there was a mining company that was coming in and we were trying to use the Forest Rights Act in that process. But the political construction of that legal issue was seen as more of a land rights issue and not about the environment. So when there are these contested interests, I think what the participatory legislative making process really enables is for that expression to be realized and perhaps more efficient use of the law. And as far as the comments that were made in terms of, like Palak's comment about social norms and even non-legal ways, I think that's essentially what I look at, is that the use of law is something that can be beneficial and have its limitations. It's not that, that looking at the sort of silver bullet solution that the law is going to provide. And plural legal systems, as much as we would like to believe that they exist, there is some hierarchy between the formal legal system and the customary legal system. And the reason for that hierarchy is that the formal legal system provides enforcement measures. And there's a formal way of challenging it. Now, whether that again is situated in a political context where it doesn't get implemented is a different question. But there is certain value in the formal legal system. But I also completely agree that the intrusion of the law can really be disruptive in certain cases, where there are existing and functioning dispute resolution methods. Which is why I feel like a more participatory approach to lawmaking might be able to open up those avenues for negotiation. And this hierarchy between the formal legal system and the customary legal system, to an extent, can also be sort of, shaved away if social norms are given that kind of, supported by social reality, where the enforcement is possible to subtle ways, and not ways which are, needs, or where there are social practices of enforcement that get developed in these societies, which can be really, not meeting human rights standards. So I think that kind of dynamism is required, but I think this whole idea of leaning towards sort of complete sort of self-reliant societies or where self-regulated societies, to an extent I feel the vision would be really difficult to fathom. Maybe it's because I come from a legal background, but it's that there's a certain value in formally recognizing a certain right. And whether the sort of process of recognizing that right is through the state-driven process or through another process, then law exists in some form, even in self-regulated societies. But what that kind of law looks like, I think, would be an interesting exercise of imagination. And I think Mani's comments are really, really valuable, and I think that's why my paper is sort of needs more work. And I think another aspect to bring in, not just the question of jurisdiction, evidence and legal procedure, but the role of lawyers in that process. And I think the history of the legal profession is not a pretty one. It's completely fraught with the nexus not just with corporations, but, and I think that's something that I would like to include in my paper, which is, as lawyers, what we get trained is your client is your client and you don't get to pick a side. If he comes to you, you have to represent him. That's your job. It doesn't matter what the moral compass of the lawyer is.
Yeah. It's a doctor. You're like a doctor.
You're like a doctor, yeah. And I think that would be an interesting aspect.
Actually got so many laws in the last since 1991.
Thank you so much, Arpitha.
Thank you.